front saying, here's what you should do next. Here's what my agency is going to do. Here's where I think you would really have an opening to advance some claim that you want to advance. And I would also say the women who are part of the labor movement, some of the women in Detroit who are part of the United Auto Workers, they actually have an office and a clerical staff, and they're doing now's clerical work for the first couple of months. So they're able to use the resources of their institutions. But certainly the fact that these women, many of them have very high contacts in labor, in civil rights, in government, means that they can do a kind of insider-outsider strategy where they're cajoling and lobbying and trying to convince and getting information from the power brokers that be, while they're also pressuring them from the outside. And it's often different women who are in different roles, but now really needed both of those kinds of pressure, sort of soft pressure on the inside and more firm pressure from the outside to get rolling as quickly as it did.
You talk about how some of their early focus was on the enforcement of laws which were supposed to give women more rights. What were some of their early battles, and how successful were they?
Yeah, so in the first place to look would be Title VII of the Civil Rights Act, which the Civil Rights Act was a very broad omnibus bill that sought to remedy a number of social inequalities in the nation, especially racial inequalities. Title VII is the portion of that law that applies to the workplace. And that law covers a number of different social categories that, your employer cannot discriminate against you on the basis of these various aspects of your identity. Your listeners will probably have a good sense of what those are. But the question of what counts as sex discrimination was kind of an open question. And as I mentioned, the federal officials, especially at the Equal Employment Opportunity Commission, were not that interested in trying to get to the bottom of it. But many of the early lawyers in particular, Pauli Murray, were concerned that the courts and the government officials who were enforcing Title VII on the basis of sex would let a lot of stuff that we would now call discrimination slide. So the big outstanding question is whether Title VII, this new federal law, is going to undercut this whole patchwork of state laws, state level labor laws that are decades old at this point. They date back to the progressive era, but they were at least nominally intended to protect women in the workplace. So they discriminate against women specifically on the basis of sex. So limiting how much and whether they can work at night, limiting whether they can get overtime, limiting how much weight they can lift on the job, limiting, I could go on and on. Some of those laws required breaks and access to water fountains and things that we would all agree that all workers should have, but others were really quite limiting. And so some of Now's earliest legal challenges had to do with the attorneys in Now finding plaintiffs who could claim that they'd been discriminated against by an employer who was following the state law. So, for example, a woman named Lorena Weeks in Georgia, who worked for Southern Bell Telephone Company, was eminently qualified for a promotion into a male-typed and much higher-paying job called a switchman. She was a clerical worker at Southern Bell. But the employer told her, well, this job requires lifting more than, I think it was 35 pounds, and by state law, you can't lift that much as a woman, so we're not going to give you this job. We're going to give it to a man with much less experience. Right. So Now's first lawyers, and there's a case out of California and one out of Indiana, where they're trying to use Title VII, this brand new law, to say you need to wipe out these state protections. They don't actually help women. All they do is, quote unquote, protect them out of the best jobs where they would be able to make enough money to take care of themselves and their families. And very famously, Lorena Weeks's lawyer in the appellate case, to prove how strong women can be, she makes part of the argument lifting a workbench over her head. And pointing out that women carry their children when they weigh much more than 25, 35, 45 pounds. And so this is a convenient argument for employers to keep giving men, reserving the highest paid jobs for men, even as moving into a time of economic retraction into the 1970s, when even those male-typed blue-collar jobs are earning less and having less status. So there's a lot of moving parts, but Now's legal strategy initially is about getting a right to strong legal equality in the workplace by removing these older sort of sexist barriers that were written into state law and had been for decades.
Interesting. It seems as if, in many ways similar to the civil rights fights around race, there are so many individual battles to be fought on a state level using, federal law or federal judicial precedent. Is that basically the same approach that now was taking? Was it focusing on federal legal enforcement regarding individual, state laws like the one that you mentioned in Georgia? Was that a big focus of its approach?
On some issues, I mean, so on the workplace issue, they're interested in finding women who have lost in the federal, like the sort of first level of federal district court, and then challenging on appeal. And if they can win the appeal, then that has a much broader reach. And if the Supreme Court doesn't review that appeal, if they can win that appellate case, then eventually these laws will all get overturned, right? If they can win in federal court, that will supersede the state laws. However, on abortion, it's a different strategy. So abortion is almost always illegal with very narrow exceptions through the late 1960s. And now comes out in 1967, which is a lot earlier than other sort of groups on the left do, in asserting that they want, abortion access available to all, no restrictions, no limits. And now chapters in different states are working on passing referenda to assert abortion rights and enshrine those into state laws. And they use different tactics in different states to do that. And now is also part of the legal challenge that eventually becomes Roe versus Wade and establishes for 49 years at least a constitutional right to abortion. The Equal Rights Amendment is another kind of a whole different set of strategies, which we could talk about if you want. But I would say in general, it's a really flexible approach, and it's driven by the problems. Initially, it's the problems that the founders see, and they're especially interested in workplace rights and workplace equality. But very soon after 1969, 1970, when now is balloons in size and becomes a kind of grassroots-driven organization, its priorities are really driven by its members, and its members have all different ideas about what counts as a women's issue, how to approach the problems that the members experience in their own lives. And so that kind of neat story I was telling about the filing the court challenges one by one, now the story gets a whole lot more complicated within just a couple of years as it gets a lot bigger and more expansive and more ambitious.
Did its scope increase along those lines? I guess more particularly what I'm interested in finding out is the degree to which now made common cause with groups around racial civil rights around sexual orientation and sexual identity. To what degree, at least for this time, in the late 1960s, early 1970s, was there a degree of intersectionality?
Well, there was certainly a lot of openness. So now's statement of purpose is quite broad and calling for a kind of equal partnership between the sexes and more equality in American life in general. And it's really the chapters that are incubating different ideas, different feminist issues, and bubbling them up to the national organization, which by the mid-1970s has like 36 national task forces, each dedicated to a different feminist issue that matters to enough members that they want to work on it. From the very beginning, now has a number of really prominent women of color who are involved. Some of those women leave quickly. That's actually not that uncommon for now founders in general, many of whom signed their name and had very little contact with the organization after that. Some of those women left for very specific reasons related to policy, related to how expensive it was to serve as an officer of an organization that had very little financial clout to speak of, although it had a lot of big ideas. But the book shows how multiple generations of women of color came to Now and demanded that their specific concerns be at the center of the organization's agenda, not at the end of some laundry list, but right in the middle. And there were very prominent Black women, especially one of the three protagonists of my book was Eileen Hernandez, who had an amazing career in the labor movement and the federal government before she becomes Now's second president in 1970. And she serves in that role for 2 years, and then she stays in now until 1979. And she's working really hard to invite more women of color into now and make now a welcoming place for them, and a cause that they feel is worth their time, has something to offer them. But also reaching out to the white women in now, some of whom have a hard time understanding that a feminist movement needs to be a racial justice movement, and that that a kind of gender first feminism does not have as much to offer women who are not straight, white, and middle class. The question of sexual orientation is also, it's kind of a dynamic story for lesbians in now as well, some of whom are there at the beginning with relative degrees of openness or sort of privateness about that aspect of their identity. But by 1969, 1970, more of them are coming out. They're making deep bonds in their chapters, bonding with other women who are talking about their own lives and realizing that they want to be open and themselves, and that their concerns as lesbians should be central to a feminist organization. And they convince the vast majority of their fellow members that that's correct, that lesbian rights are women's rights, and now officially embraces or endorses lesbian rights in 1971. But for lesbians too, there's a continued struggle to convince the full spectrum of now members that lesbians' specific concerns should be at the center of the organization's agenda and not kind of a side issue. So for both of those identity groups within now, there's an ongoing push for real representation, for a real embrace and endorsement and sort of muscle behind their specific concerns, not just lip service. But again, it's a similar case with lesbians, that as some get frustrated, some leave, more come, and they point to now's open-ended agenda and claim to stand for all women and say, we're women too, and our concerns are just as important as anybody else's. And the social hierarchies that structure American life outside of now should not structure our organization as well, if it's an organization that's dedicated to real equality for all women. And women have very different ideas about what equality is and very different perspectives on that. And now I think worked best when it had a kind of openness and expansiveness and locally driven thrust, so that lots of different women could see themselves in it and could pursue their version of feminism from the grassroots, but benefit from the visibility and the clout of a national organization with real media presence and real political heft.
How was Now involved in the push for the Equal Rights Amendment?
Yes. So the Equal Rights Amendment was a longtime priority of some feminists, some of whom wanted it all the way since the 1920s, since the passage of the 19th Amendment, which extended suffrage rights to millions of women. Of course, not all women, but many. Other feminists thought that strict legal equality would only disadvantage women who needed gendered protections in their marriages and in their jobs. The ERA kind of has its ups and downs as a proposed amendment across the decades from the 1920s forward, but it's as quote unquote second wave feminism starts to blossom in the mid 1960s, there are still some ERA advocates who are alive. They're later in years at this point, but they've kept the issue alive as something that they want to see written into law. And they, as well as some of their younger allies, convinced Now to endorse the ERA in 1967. So that's the second big policy stand, kind of bold position that Now takes at that 1967 conference. So now chapters are working locally, but they're also protesting federally in Washington, and lobbying their specific lawmakers to pass the ERA, to get it through Congress. And with bipartisan margins that are hard to imagine today, the ERA passes both houses of Congress with broad bipartisan support in 1972. But Congress does give the measure a time limit, which is relatively unusual for a constitutional amendment. They give the states 7 years for 38 states to ratify the ERA in their state legislatures, and then the ERA will be ratified federally and it will be written into the Constitution. So now and other feminists are feeling pretty confident in the early 70s because the amendment